I would like the court to know that I am a victim of domestic violence. Say that if we are going, if it's in your judgment, if it's in your best judgment to push this back further, that I would like some temporary orders on child support and custody of the children until the divorce is finalized.
I have no objection to that request.
Interim order. Is this a custody dispute at all, or can you at least admit or agree or concede that mom has current possession of the child without conservatorship orders?
Children in the home that the parties were residing in, which she owns, as I think it will be separate property. So they're on a schedule and they're on a routine. But again, my client's position is very different.
All right, guys, we open strong. The mother steps up and declares, "I'm a victim of domestic violence." That sets the tone right away. She pleads for temporary child support and custody until the divorce is finalized. But hold on, the father's side jumps in quick, saying they've got no objection, yet they're not exactly agreeing either. The lawyers start sparring over who really has possession of the kids. The air in the courtroom? Heavy, tense, and ready to explode.
Of what he would like moving forward. And I think.
Well, I'm not calling it conservatorship, but is there any dispute about who has primary possession of these children? Or even possession?
She currently does, because she has established that by her own accord, not by
agreement. So,
well, if I send it up, I'm trying to prevent the snatching thing.
I think from my
clients, we could maybe agree on a temporary basis on one issue, but I don't we asked that everybody stay in their current school districts for geography, and even Ms. Cosford would not agree to that. So.
Well, it's the end of the school year. You don't think you can get to a court before school starts in the fall and sort that out there?
Yes, I would hope so.
I'm hoping we'll be in court in June.
Well, yeah. But I'm trying to put something that just at least puts that stamp of, so people don't get the idea that possession is 9/10 of the law and keeps the children and then has that advantage before mom can get into court if the children.
Up, this next exchange gets messy. The judge asks straight out if there's a real custody dispute. The father's attorney hesitates, dodging a full answer while trying to clarify the family's situation. Mom's got the kids right now, but not officially. The father's team wants to keep things routine, but not under her terms. Then the argument pivots to school districts' geography, schedules, and control. The judge just wants peace, but both sides are gearing up for war.
We've been residing with her during the separation period, and so it sounded like you might agree with it, but then I'm not sure you just did with the school district issue.
No, we made an offer and she did not agree to any part of our offer.
So we are disputing geographic location, conservatorship, possession, child support, arrearages. I think probably,
let's see what else.
Conservatorship, whether it's joint or whether it's primary.
We want a joint with no primary.
And I believe, correct me if I'm wrong, I think she asked for sole managing. So.
Okay, well, maybe if I do something you don't like it, you can appeal that. But anything else, Ms. Ferguson? Well, let me finish, Ms. Ferguson. Anything else, ma'am?
Asking for that continuance so we can consolidate this, hear it all at once, also deal with any other issues with regards to the divorce at the same time, because those can affect the children. And I feel like doing it piecemeal is...
All right, guys, it's heating up. The father's lawyer insists the mother refused every offer: child support, possession, even school boundaries. The judge pushes back, questioning if this could wait until summer's over. Both lawyers know the storm is coming. Then mom's attorney, Miss Ferguson, steps in, asking to consolidate everything: divorce, custody, child support, all in one battle. She calls the process unfair and piecemeal, demanding a single showdown. You can feel the judge weighing every word.
Unjust and unfair, not only to the parties, but also to the children.
Okay, and Mr. LC, if you want to say something, what is it, sir?
Yes, Your Honor, I have a list of reset dates if necessary.
Okay. And Ms. Cosper, did you have anything else you wanted to say?
Just I stand by that. I think it's been a long time now, and having some temporary orders until the divorce is finalized, and continuance of what we've been doing in regards to possession, and then establishing set child support for the children would be beneficial for the children. So that way they can continue on the way that they have been, and we can both be legally binded to that agreement. And the children can continue to see their father the same way that they've been seeing them over the past year. And we can establish a set number for child support. And that will actually take something off the plate.
Hold on tight, because now the mother herself speaks again. She stands firm, saying the kids' stability comes first. Temporary orders, she argues, would protect them from chaos. She just wants things on paper legally binding so both parents know where they stand. Her tone? Calm but desperate. She's fighting not just for control, but for peace of mind. Even the judge seems to soften, listening closely as she outlines what life's been like since the separation.
In the divorce process, I believe, because unless they want to appeal, but I think it's in the best interest of Gavin and Mila in order to get something legally on paper from now moving forward.
Well, if you think it's been a long time since the filing in November, even the application in August, then, or whenever that was, you haven't been around court for much time. You're not going to get a divorce overnight. You're not going to get orders overnight. It just doesn't happen that way. It's already been 5 months to get here. I've got lots of cases. I hear tons of stuff. AG has thousands of cases they process. And so it just doesn't happen the way people want it to happen, which is on their time. It works on our time. So now
this is where the reality check hits. The judge reminds everyone court doesn't move on their time. It's not happening overnight, he says bluntly. He's seen hundreds of these cases, and patience isn't optional. The mom asks if she can sign a waiver only if temporary orders are made today, but the judge shuts that down immediately. That ain't gonna happen, he says coldly. Everyone realizes this isn't just legal talk, it's a game of patience and power.
there's a question of the divorce. You haven't even been served with it. Are you willing to sign a waiver on that, or you want official service with the pleadings by a sheriff or constable?
I would only be willing to sign a waiver if we could establish temporary orders today.
Well, that ain't gonna happen. Okay. I'm not gonna make you sign waivers and they be conditional or whatever.
Okay.
This is what I'm gonna do. This case is not ripe or ready or for this court because of the issues I've already heard.
Your
and
Honor,
the
I'd
time
have
it's
to
gonna
object
take.
to a referral. I think the onus is on Ms. Ferguson to get a setting, and I'd like to keep this on our docket in case that doesn't happen.
I'm not gonna do that, Mr. Asif. I'm gonna refer the case out.
Sure.
And I will make certain orders in the order, and Ms. Ferguson can appeal me if she doesn't like it. And if you don't like it, you can appeal me and make me take it, but that usually doesn't happen either, sir. This is what I'm gonna do. Interim order. Referral to district court to be set for temporary orders as soon as practicable. After
Now we shift gears. The judge decides this case isn't ready for his court. He starts making interim orders, setting the case up for referral to a higher court. Lawyers scramble objections, clarifications, appeals threatened. But the judge holds his ground, declaring mom currently has custody and the father can only see the kids by agreement. You can almost hear the gavel in his voice. The courtroom's calm masks the intensity. Both sides know this is just round one.
service or appearance or waiver on the mother, the custodial parent. In the meantime, I'm going to make a finding. I've heard enough, including especially from your lawyer, Mr. Cosper, that mom has the that the children have been residing with mom. So I'm going to make a finding that the custodial parent has possession of the children. And that any access by the non-custodial parent shall be by agreement until further orders of a court. That Ms. Cosper was recently retained.
I think you meant Miss Ferguson.
Was recently retained. That's okay. I'm sorry to correct you, but just so
No, I
notes
looked
are
up and I
correct.
saw Cosper, and I'm thinking of his side, but they're both Cospers. I'm sorry. Yeah, yes, that Miss Ferguson was recently retained.
All right, this part's critical. The judge formalizes his findings. The mom's got possession. The dad's access stays limited until new orders arrive. He grants Miss Ferguson's continuance request despite mom's objections. The tone gets sharp procedural, but underneath it all, you can feel tension brewing. The judge insists the case's complexity makes it unfit for this division. Papers shuffle, people nod, but make no mistake. This is just the calm before another legal storm.
And her request for continuance for full temporary orders is granted over the mother's objections or the custodial parents' objections. And you can put their names. I'm just using that as shorthand rendition right now. That this court finds that due to the contested issues and exhibits and possible witnesses, that this case is not appropriate for the 4D court. The other thing I kind of wanted to say, because there's not a divorce yet, so I'm only referring to the AG case, and I don't want it to fall through the cracks. And I assume if you just got hired, Ms. Ferguson, you're not intending to let that happen, but sometimes things get to the bottom of the stack if it's in anybody's interest to delay, and I don't want that to happen. But I want a finding in there also that father's attorney, did I already say that? Well, I talked about service and appearance, and I meant on the divorce, but I didn't say that there's a divorce pending. So somewhere that that father's attorney has, I just guess, asserted that a divorce will be filed. Oh, it already has been filed. I'm sorry, I did have a cause number. Trying to think right. No, so I don't need to say that. The divorce is already on file and a finding that it's under cause number blah, blah, blah. And that consolidation and service on custodial parent still needs to occur.
Let's break it down. The judge continues explaining how delays happen. Emphasizing he won't let this case fall through the cracks, the attorneys discuss consolidation, merging the divorce and AG case to avoid conflict. Everyone finally agrees. You can tell the judge's patience is thin, but his control is iron tight. He wants this cleaned up fast, legally correct, and off his docket. The mom hesitates but ultimately agrees to combine. The courtroom finally exhales for now.
Make that at the top somewhere with the referral. But yeah, and I just want to clear that due to the lengthy nature of this case, I'm not going to hear it.
Okay, Your Honor, could we not consolidate this matter now?
I don't have a problem with it if you want to draft it. Ms. Ferguson, would you have a problem with it? You're muted for some reason.
Sorry, I have no problem with that. So go
Ms.
ahead.
Cosper, we could do one thing quicker, but you haven't even been served, and so I won't even ask you to sign it. But would you have a problem if I put the two cases together because there already exist our AG case with that cause number and the divorce case that is on file already? It's to me, it's an administrative thing that needs to happen anyway, because there's no way two courts are going to hear two different things on the same party, so we have to put the cases together. Would you have any objection for me to at least do that today and get that paperwork out of the way, even if you haven't been served?
Um,
It's going to happen anyway down the road, and it could just take longer and cost more because Ms. Ferguson will do the paperwork instead of the AG doing the paperwork for free, and I'm me signing it for free. Well, all judges would sign it, any judges would sign it, but it needs to happen legally before a court will hear both cases.
I understand, Your Honor. I would not be opposed to combining the cases.
Okay. Then I'm not going to ask you to sign it because I don't know if that would constitute making an appearance without service and or signing a waiver. So I just want you to be aware of that. And then frankly, Ms. Ferguson, well, I do want you to sign it since you filed the divorce. So a separate order of consolidation of these two cases, and I assume you want the surviving order, the divorce cause number to be the surviving number.
I think that makes the most sense, Your Honor.
Consolidation into divorce with proceeding under the divorce cause number. Okay, so I want two orders, an interim order and a consolidation order. And I think I covered everything I wanted. And I get your point, Mr. Asif, but I don't think this is going to fall through the cracks. There's a lawyer on board, and Ms. Cosper. I want to say Cooper too, because that just looks like a no with my reading classes. If you're not getting any feedback from Ms. Ferguson, you can ask the AG to place the temporary orders hearing and have it set before she does. However, I hope she does her job and gets it out quick so you can have a hearing in the next 30 days or so.
All right, guys, we're deep into procedure now. The judge orders full consolidation under the divorce cause number. He's tying every loose end together. He reminds everyone, this isn't an emergency. Both parents are co-parenting fine. It's not about sides anymore. It's about structure. But don't get it twisted. He's firm that if anyone stalls, he'll step in. You can feel his authority filling the room, closing every loophole before this thing drags out longer.
So, or 4 or 5 weeks at least, so you can get down to business. I didn't hear any emergency that made me think I absolutely needed here today, that y'all have actually been co-parenting and working fairly well, and he hasn't kept the children from you and you haven't kept them from him. This is just a total Band-Aid approach so the court knows I did something and sent it away because now I can't hear the temporary orders hearing due to the lengthy nature. I had a bunch of cases and I probably still have more hearings left today. So it's not right for this court. Did I leave anything out, Ms. Ferguson, that you think might be necessary?
No, I think that takes care of everything, and this will make it go faster, that I don't have to file the consolidation and set that, so I appreciate that.
Any chance you need to appeal any of that? I guess I won't make you tell me, but.
I would hope not, but I would need to discuss with my client, and I would need to review everything, obviously.
Okay, because if I thought you were going to appeal something that was objectionable, I'd try to fix it to make it unappealable. But I don't think I've said anything other than finding a possession that you could have possibly want to appeal. But
right.
Okay,
I think
I'll let you
we
figure
can
that out.
still deal with the possession order and the conservatorship when we have temporary orders, hopefully in a few
Correct.
weeks.
And Mr. Asif, I tried to talk slow because I was writing it all down so I don't have to remember it, but I hope you were doing the same. You'll have everything in there.
Yes, Your Honor. Just to clarify, so you'd like me to draft a referral order setting this matter for temporary orders as soon as practicable after service and appearance or waiver on Ms. Cosper for divorce under the divorce cause number. You're requesting a finding that Ms. Cosper has possession of the children, that any access by Mr. Cosper will be by agreement until further orders of the court, that Ms. Ferguson was recently retained, and that her request for continuance for full temporary orders is granted. Over Ms. Cosper's objections, the court finds due to contested issues and exhibits and possible witnesses that this case is not appropriate for the 4D court due to the lengthy nature of the hearing. And I believe you're also asking me to write a consolidation order consolidating the AG cause with the divorce cause under the divorce cause number. Is that all correct?
I think so, but the title of the first order needs to be interim order and order of referral,
Interim order and order.
not just referral. It does contain some content. I'm not going to say it. And also on the request for motion for continuance, that's too long, but those two things, interim order and order of referral. And then the second one is consolidation order of consolidation. Okay, I think I got it. Ms. Cosper, on the state's case, is there anything else without having a contested hearing today that you think I should consider adding to my interim order or order of referral?
What about support for the children, financial support for the children?
If I'm not hearing it to determine custody and visits, I'm not hearing it for child support. It all has to be heard at once.
Yes, ma'am. Yes, Your Honor. I don't have anything that I'd like to disagree with. I appreciate your interim orders as they stand, and I look forward to getting this taken care of.
And here's where it all wraps up. The judge dictates final instructions like a general. Interim orders, referrals, consolidation all locked in. The attorneys confirm details one by one, repeating everything to make sure it's airtight. When mom's lawyer asks for child support, the judge shuts it down. Not today. It's a clean, controlled ending to a chaotic hearing. The tension fades, but the message is clear. The real fight hasn't even started yet.